Commission meeting. This meeting has been noticed in compliance with the South Carolina Freedom of Information Act. This commission acts in review and recommending capacity for comprehensive plan amendments, text amendments to the Charleston County Zoning and Land Development Regulations Ordinance, rezonings, and plan developments. The commission has decision-making authority on road name change requests, public project reviews, appeal of administrative decisions on final plats, and subdivision matters, as well as other matters pursuant to Chapter 29, Title 6, Section 6-29-340 of the Code of Laws of South Carolina as amended. If you wish to speak at today's meeting, fill out a sheet at the by the front door. My name is Cindy Floyd. I'm the chair of the Planning Commission. For those of you who cannot see nameplates, to my right I have one guy over, Pete Pilatus, Luke Morris, Marlena Davis, and Adam McConnell. To my left, the commission members are David Kent, Warwick Jones, Logan Davis, and Kent Prasa. Also seated to my right is Attorney Mark Bell, and seated to my left is Joel Evans, Director of Zoning and Planning. Joel, would you please introduce the staff that are present?
Sure. Andrea Melisick, the Deputy Director. Emily Wynn, she will be presenting one of the cases. Marche Miller and Tamara Avery will also be presenting one of the cases. Also in the audience, Matthew Husman, he's with our subdivision, and Sharon Lynn, she's with our subdivision staff as well. And Walt Smalls, the Deputy County Administrator for General Services.
I would like to remind you that in order to get good recording of the meeting for the minutes, please speak loudly and clearly, and please do not talk over one another. The first item on the agenda is approval of the minutes from August 14th, 2023. Is there a motion and a second?
Move to approve.
Okay. Would you please call the roll?
Commissioner Logan Davis. Aye. Commissioner Marlena Davis.
Aye.
Chair Floyd.
Aye.
Commissioner Jones.
Aye.
Commissioner Kent.
Abstain.
Commissioner McConnell.
Aye.
Commissioner Morris.
Aye.
Vice Chair Pilatos.
Aye.
Commissioner Prasa.
Aye.
The ayes have it.
So we'll do comp plan first. It didn't make the chair agenda. We're going to do comp plan update. Yeah, it didn't make the agenda. That's what these speakers are for, the comp plan update.
When is that going to go?
Right now. So we'll have the comp plan update first before we get into the cases. So, yeah, go ahead.
Yep, just real quickly, so we finished our 6 public workshops, which are in person, and our online public forum closed at the end of last month. We got a good number of comments, which we are currently putting together to send to you for the subcommittee. So by the end of the week, you'll get your subcommittee packets. So that'll give you about 10 days or so to review them in advance of the subcommittee meetings, which will start towards the end of the month. And I think we have 2 people who want to speak on the comprehensive plan.
And we didn't do the pledge yet either.
Should we do that or skip it?
I think we should do it. Yeah, it's 9/11.
Before we hear from the speakers, we're going to stand and say the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Okay, speakers for the comp plan are George Freeman, and after that we'll hear from John Zolgar. And are these limited to 2 minutes?
Yeah, start with 2 minutes, yeah.
Okay. Please try to limit your remarks to 2 minutes.
No problem. Good afternoon, George Freeman, 1450 Bowman Road. The only comment I have, and I think I may have done it during one of the meetings that were in the community. Some years ago, the community and the county got together and came up for a plan in the 7-mile community. I think it was called some kind of village something when it comes as far as the zoning. But my concern is that when we did that, Highway 17 was 4 lanes, but since then, Highway 17 has become 6 lanes. And the reason I'm mentioning this is that when we did the village commercial, or whatever we decided to call it, we decided that the commercial would be able to extend from Highway 17 500 feet into the community. But if that still stands as saying 500 feet from Highway 17, you really added more feet into the community. So my concern is that that needs to be adjusted for that expansion of Highway 17. Otherwise, there would be the possibility of moving commercial property even closer into the community. And I'm just here today to try to bring that to your attention and make you aware of it so that you wouldn't have that impact on the 7 Mile community. Thank you.
Good afternoon. John Zaloga with the Johns Island Task Force, 5528 Frisco Lane, Johns Island. Relative to the comp plan, I think that staff's been doing a great job going out and getting input from the community. One thing I do want to bring up is, throughout the comp plan updates, as well as what's in the current comp plan, the urban growth boundary has been key in there. And this, all the drafts I've seen, it's even been trying to strengthen it even more, which I think is fantastic. But one of the things that's inconsistent is Table 3.1.1 of the comp plan, Table 3.1.1, which is the future land use residential densities. And to me, that's inconsistent with what the objectives of the comp plan are. And the comp plan, it talks about not only conserving the urban growth boundary line itself, but what's behind it, right? In other words, the densities behind it. And in that Table 3.1.1, it allows AG8 to have double the future densities, which to me is inconsistent with the whole objective of the comp plan. And for RR, it allows triple the densities. Both of those are outside the urban growth boundaries. So, so to me, those are inconsistent and should be at the very least removed. In that same table, there's exemptions for density increases for Edisto Island and Wadmalaw. So there's precedence that if the desire is not to remove them entirely, to actually carve out exemptions for Johns Island for those. Again, the concern is Table 3.1.1 being inconsistent with the comp plan and the preservation of the land outside the urban growth boundary. Thank you very much for your time.
Okay. No,
Okay,
we'll take that.
go to this. Parker Ferry.
Yeah, yeah.
The next item on the agenda is a request to amend Article 5.12, the Parkers Ferry Overlay Zoning District, Table 5.12.8, Business Service Nodes and Commercial Properties Density, Intensity, and Dimensional Standards. Ms. Nguyen is going to present that.
Thank you. This is a request, like you said, to amend Article 5.12, the Parkers Ferry Overlay Zoning District, specifically the density, intensity, and dimensional standards for the business service nodes and commercial properties within the overlay, to allow for buildings to exceed the maximum 5,000 square foot building size, subject to special exception approval by the Board of Zoning Appeals.
Okay.
That's what he said. The applicant specifically requests to amend note number 4 in table 5.12.8 to add the statement that buildings may exceed the maximum square footage requirement if reviewed and approved in accordance with the special exception procedures of this ordinance. And you'll see that note is redlined at the bottom of this chart. According to Section 365 of the Charleston County Zoning and Land Development Regulations Ordinance, special exceptions may only be approved if the Board of Zoning Appeals finds that the proposal meets these criteria, is consistent with the recommendations contained in the Charleston County Comp Plan, and the character of the base district purpose and intent, is compatible with existing uses in the vicinity and will not adversely affect general welfare or the character of the immediate community. Adequate provision is made for such items such as setbacks and buffering, including fences, landscaping to protect adjacent properties from the possible adverse influence of proposed use such as noise, vibration, dust, glare, odor, traffic congestion, and similar factors. Where applicable, the property will be developed in a way that will preserve and incorporate any important natural features and complies with all
applicable rules, regulations, laws, and standards of this ordinance, including but not limited to any use conditions, zoning district standards, or site plan review requirements of this ordinance, and that it does not hinder or endanger vehicular traffic and pedestrian movement on adjacent roads. And in granting a special exception, the Board of Zoning Appeals may attach conditions regarding the location, character, or other features of the proposed building or structure. Some history about the PFO, the Parkers Ferry Overlay Zoning District. Prior to the adoption of the PFO in 2017, the properties that later became incorporated into the overlay were designated for the Rural Cultural Community Protection Future Land Use in the Comprehensive Plan. The overlay district is the first example of the implementation of this future land use designation through zoning. The process to develop the overlay zoning district included working closely with community members and stakeholders who felt that residential densities should remain low and new development should respect the existing land use pattern, which is largely rural with historically and culturally significant properties. However, they recognized the need for employment in the area and wanted to allow businesses but limit the scale and scope to remain consistent with existing development. As a part of the PFO planning effort, a supporting document entitled Parkers Ferry Community Plan was included as a resource within the comprehensive plan, which included the results of the community needs assessment and provided recommendations and strategies developed in coordination with the area residents to address issues identified by the survey. The PFO implements the Community Plan Strategy 2.1, which states adopt amendments to the Charleston County Zoning and Land Development Regulation, including but not limited to an overlay zoning district as applicable. The PFO includes a residential area as well as business service nodes and commercial properties. The uses in each area are identified and determined by the community. Allowed uses within the residential area include single-family detached housing by right and some other low-intensity recreational, civic, and institutional uses allowed either conditionally or through the special exception process. The business service nodes and commercial properties allow for more intense office and commercial uses such as healthcare uses, animal services, administrative and professional offices, and retail sales. Higher intensity uses such as gas station and resource extraction require approval through the special exception process. Building sizes are limited to 5,000 square feet of gross floor area in the business service nodes and commercial properties. Since its creation, the PFO has been amended several times, including twice by this applicant, to change several properties along Savannah Highway from residential to commercial to allow for the expansion of an existing agricultural equipment business on TMS 121000048. Properties within the business service nodes and commercial properties are primarily located off arterial roads throughout the Parkers Ferry area, including Savannah Highway, Old Jacksonboro Road, and Highway 174. All properties within the PFO that are not zoned business service node or commercial are zoned for residential. Residential properties have a density of 1 dwelling unit per acre. And these are some uses allowed within the business service nodes and commercial properties. They include agricultural sales or services, medical office, food sales, and retail sales. Other more intense uses can be conditionally allowed or by special exception approval from the BZA. According to Section 336 of the Charleston County Zoning and Land Development Regulations, text amendments to the ordinance may only be approved if the following criteria have been met. The applicant submitted responses stating that the approval criteria was met. Staff agrees the approval criteria have been met and the proposed ZLDR text amendment allows flexibility in building size to meet the needs of businesses within the business service nodes and commercial properties, but through the special exception process allows for public input on proposed projects that may exceed 5,000 square feet. For this reason, staff recommends approval, and this request was noticed as required.
Thank you for that comprehensive report. Okay, We only have one person who signed up for public comment. Mr. Steen, do you want to add anything to the staff report? Okay. All right. The case is now closed to public comment. Is there a motion and a second from the commission?
Second.
Are there any discussion from commission members or any questions for the staff?
Yes, I'd like to ask a question or two. It looks like it's the overlay is expanding. The zonings, the rezonings that have occurred have been from residential to commercial, so it's growing. Is there a reason why there's a 5,000 square foot limitation on the buildings there, and why anything greater would require special exception approval? Why couldn't it just be that they could have bigger buildings without additional approval?
So as it exists right now, you can't have bigger buildings than the 5,000 square foot maximum. So this request would allow for you to achieve that through the special exception process. Based on my knowledge about the history of the adoption of the overlay, staff worked very closely with community members and stakeholders, and it was the intent of the community members to keep building massing and scale low and down in order to align with the existing land use patterns and architecture of the area.
I see. But has there been any thought to, is that still the consensus since this area appears to be expanding and getting larger, is to allow bigger buildings as a use of right without any additional approvals?
Well, this is the first request for a text amendment that we've received of that nature. So as far as we are aware, no. But like I mentioned, there is that document that the community had done to assess kind of the area. I can't remember what year that was done off the top of my head, but that was the general consensus at that time. And given that we've not heard anything from the community beyond this application.
I see. Thank you. And a question for the applicant. With the special exception approval stipulations, that suits your needs for what you need to do? Thank you.
Any other questions or comments? Luke?
I just had a question for staff. They could have asked for a special exception without having this amendment, correct? Or you can't
No.
even ask for a special
No,
exception?
you can't ask for
Okay.
anything, yeah.
Interesting. All right, well, that's all I had.
Anybody else? Okay. There's no further discussion. It's time for the vote. Would you please call the roll?
Okay. Commissioner Logan Davis.
Aye.
Commissioner Marlena Davis.
Aye.
Chair Floyd.
Aye.
Commissioner Jones.
Aye.
Commissioner Kent.
Aye.
Commissioner McConnell.
Aye.
Commissioner Morris.
Aye.
Vice Chair Pilatos.
Aye.
Commissioner Praza.
Aye.
Ayes have it.
County Council will hear this request at their public hearing on October 10th, 2023 at 6:30 p.m. in council chambers, and again at their October 19th, 2023 Planning and Public Works Committee meeting at 5 p.m. The request must then undergo 3 readings for approval at council's discretion. The next agenda item is case number SBD-VAA-07-23-00004, an appeal of a subdivision-related administrative decision regarding the approval of the final subdivision plat for 3814 Watson View Drive, parcel identification number 614-00-00-069. Pursuant to Article 3.14, Appeals of Subdivision-Related Administrative Decisions of the Charleston County Zoning and Land Development Regulations Ordinance, an appeal shall be sustained only if the Planning Commission finds that the administrative official erred. The decision of the Planning Commission shall be accompanied by specific written findings of fact and conclusions of law, clearly stating the reason for the decision. At least 2/3 of the members present and voting shall be required to reverse any order, requirement, decision, or determination of any administrative office or agency. The order of the hearing on this case will be as follows. First, staff will give an overview of the appeal application. Then the applicant will be given 5 minutes to speak. Following that, I will call each person who signed up to speak, with each speaker limited to 2 minutes. The case will then be closed to the public comment, and staff will make a presentation regarding the application. I will then request a motion and a second. Discussion can occur after the motion is made and seconded, and then we will vote. So will the staff please introduce the case?
This is overview of appeal SBDVAA 0723-00004. The appeal is for subdivision application SBDV 0922-02205, which subdivided the property located at 3814 Watson View in the 10 Mile community into 11 lots. The property owner is Levi Grantham LLC. Property size is 3.2 acres. Current zoning district is R4. And the final subdivision plat was recorded at the Charleston County Register of Deeds office on July 14th, 2023 in page, plat book L23, page 0267.
Excuse me.
Yes.
I'm having a hard time following along with the slides on the screen and what we have on these devices. They don't match. I need some help, apparently.
Marche's coming.
Thank you. Okay, here's what I have. Okay. Thank you very much. Thanks.
Okay.
I'm new to this.
All right. So this is the future land use map of the subject property in relation to the surrounding area. This is the current zoning map of the property with the surrounding area. This is the GIS aerial view of the subject property. And this is the recorded plat that was recorded at the Register of Deeds office. The appellant, South Carolina Environmental Law Project, on behalf of the 10 Mile Neighborhood Association, is appealing the administrative decision based on ZLDR Section 8.1.2E, Certificate of Historic Appropriateness, and ZLDR Section 11.1.1, Ordinance Compliance. And now it's time for the appeal application presentation.
Can we hear from the applicant? First on the list is Ellis.
Well, these are just the speakers,
Oh, this
so it's
is-
just the
Oh, the
applicant.
applicant, sorry.
What now?
Good afternoon. My name is Ben Cunningham, 510 Live Oak Drive, Mount Pleasant. I am here on behalf of the 10 Mile Neighborhood Association. And 10 Mile, as you all are doubtless aware, is a historic district in Charleston County. And this development, the property at issue, is within the boundaries of the historic district. The subdivision regulations, the LDR itself, 8.1.1F, says one of their main aims is to identify, protect, and preserve scenic, historic, and ecologically sensitive areas. To that end, ZLDR 8.1.2E says, prior to getting a final plat approval for a subdivision, the applicant must obtain a certificate of historic appropriateness from the Historic Preservation Commission. And make no mistake, it says subdivision plat, which means final plat. As you'll see, the subdivision final plat says a subdivision plat of, in this case, Watson View. It also makes sense because it doesn't say preliminary plat, it says subdivision plat. Anyway, the applicant submitted an application for the final plat for this development September 16, 2022. Staff told the applicant, you need to go get a certificate of historic appropriateness from the HPC. Nevertheless, staff approved the incomplete, and I mean incomplete as in the applicant had not obtained a certificate of historic appropriateness from the HPC final plat on June 14, 2023. Not only did the applicant not have a certificate at the time the final plat was approved, the HBC rejected the applicant's application in a meeting on July 19th, 2023, which is when my client first became aware that the final plat had been approved by staff. Now, HPC voted to deny the Certificate of Historic Appropriateness on 3 different grounds. It wasn't just the density issue that you guys have been hearing a lot about. That's criteria D. They also rejected it for criteria B, which encompasses inappropriate related to exterior form and appearance of any proposed additions and the effect of those distinctions on the other structures, and C, related to the application of the Secretary of the Interior Standards for Treatment of Historic Properties. And then, of course, D. In any event, the ZLDR requires the applicant to obtain the Certificate of Historic Appropriateness prior to final plat approval, because at that point, when the final plat is approved, the train has left the station, so to speak. At final plat approval, you're talking about vested rights being established. And there isn't an issue of vested rights here. You can look at the vested rights ordinance of Charleston County, which requires significant government action in order for vested rights to attach. The 2 examples that relate to plats don't apply. One requires the Planning Commission itself to have approved a preliminary plat, which didn't occur. The other relates to the planning director approving a final plat, which is what we're here about. The Vested Rights Act does not apply either. That requires a site-specific development plan, and in particular, it requires the recordation of a subdivision plat, meaning a final plat. The preliminary language in that does not relate to a final plat or a subdivision plat. It talks about a plan. And if they wanted to make preliminary plats the standard, then they could have said preliminary plats. They didn't. Now, you may hear other justifications for this. I'm not sure what they may be. You may hear that the Historic Preservation Commission decision was wrong, or there is a problem with the ordinances in effect. But the ordinances in effect were approved by county council. They are the law that governs this, just like ZLDR is the law that says you have to obtain a Certificate of Historic Appropriateness prior to final plat approval. Now, as far as the HBC's statutory authority, which I saw in some of the materials, Section 629.880 just says the HBC derives its authority from ordinances. And 629.870 says the local government may restrict or protect historic districts and neighborhoods by means of restriction and conditions governing the right to erect, demolish, remove, or another way is alter buildings or structures in that district. And here we're talking about the erection of additional structures. Setting all of this aside, the fact of the matter is the staff approved a final plat that didn't have a certificate. Whether the staff agrees with the ordinance is beside the point, and nor does it matter if the ordinance might one day be changed. We have to apply the ordinances that are before us right now, and of course you have to apply the ordinances that are in effect in your review of this appeal. To that end, ZLDR 8.5.6a says the Planning Commission shall not be authorized to approve modifications or waivers of ordinance standards through the appeal process. All we're asking is for the ordinance to apply as it's written and require the applicant to obtain a Certificate of Historic Appropriateness prior to final plat approval. Thank you.
Okay, thank you.
No.
Okay, now we'll hear from the public. Each speaker will be limited to 2 minutes. Please state your name and address before giving us your comments.
And Alice Leisman might be requesting 5 minutes. Oh, okay.
Ellis Gleesman?
Thank you, Madam Chair. Ellis Leesman on behalf of the property owner. And seeing that I've got 2 minutes, I had some materials on a presentation, but I'm just going to move forward very quickly. A very similar appeal was before this same body in June of this year, and it was unanimously rejected 8-0 on the basis that the county, oh, thank you so much, Emily. The county has recognized that the Historic Preservation Commission ordinance, as it's currently written, contains an illegal delegation of authority to the Historic Preservation Commission that is actually belongs to this planning commission. And that the HPC, as I'll call it, does not have rights over plats. It can't reject plats. It can't review plats. And again, in their meetings, the HPC's purview was clarified, that they're not to make determinations about land uses, about subdivision plat applications, density, intensity, or dimensional standards. The appellant's statements about what does and doesn't constitute vested rights are respectfully incorrect. As you all know, you get a preliminary plat first, and then what do you do with that? You're going to buy that property, and you're going to spend millions of dollars installing infrastructure and roads. The suggestion that while you're doing that you don't have vested rights, and you're just putting in millions of dollars into a property on the hope that something doesn't happen is categorically wrong. That's not how things work under our system. Now, by making that statement about the HPC's purview and by putting the amendments before this body that you last month approved by a vote to 6-2, that tomorrow will be heard at public hearing by the county is correcting that error in the ordinance. Now, the county recognized, and Ms. Avery, Mr. Evans, and others, that the county shouldn't follow an ordinance when it's recognized to be legally wrong. So to give a body like the HPC power over plats and final plats, when state law specifically says that that's an authority that's reserved only to the Planning Commission, is wrong. So for those reasons, ladies and gentlemen, I would ask that you reject this appeal and allow for this process to continue forward. Thank you.
Thank you. Could you give us your address, please?
Oh, yes, ma'am. 418 King Street in Charleston.
Next is Ben Cunningham.
I've already been mistaken, Madam Chair.
That was him. He's the applicant.
Yeah.
Okay. We need it.
Filippo Ravalico.
Filippo Ravalico.
Filippo Ravalico, 510 Live Oak Drive, Mount Pleasant. And good afternoon. This is the third time this commission is called to deliberate on historic preservation matters since June. In June, the appeal that Mr. Lisam just reminded you of was not decided on the grounds that he discussed. It was decided on the permit extension bill, which is a totally separate matter, and we can talk about it another time. In August, last month, you recommended amendments to the ZLDR without even having a chance to look at the underlying driving and substantial changes proposed to the historic ordinance, historical preservation ordinance. Today, we're here to apply the law, the ZLDR, to two pretty straightforward questions. Was a certificate of historic appropriateness issued before the preliminary plat approval? Before the final plat approval, excuse me, and were those approval within the 2 years from the preliminary plat? Now, it's interesting how hard it is to get a straight answer to a seemingly straightforward question from staff. It's been going on for a few months now. In June, they kind of ambushed you without sharing one shred of information about the matter, and that's probably what led the partial decision on just an unrelated permit extension bill. Today, if I'm not wrong, they're asking you to apply a future ordinance. No, it's going to change. We know how it changes. Let's apply the future ordinance. The legal standard is fairly clear. It's 11.11.1. No activity regulated by this ordinance shall be undertaken except in full compliance with the express provisions of this ordinance. Now, this is a standard that applies to your deliberation as well, of course, and I hope you will do your job. It's particularly important at this time when the optics on this matter is looking increasingly bad for the county. You can make a small but important difference. Thank you.
Thank you.
That's it. That was this right here. So the case is not closed to public comment.
The case is now closed to public comment. We will hear the staff's presentation and rebuttal.
Okay. Good afternoon. My name is Tamara Avery, and I'll be presenting the subdivision appeal applications. Here's the background on the property from the beginning when staff saw it. May 2019, it was submitted for preliminary plat review. September 20th, the preliminary plat was approved by staff, September 2020. August of 2021, a revised preliminary plat was approved by staff. June 2022, 10 Mile Community is designated as a historic property or historic district. September 16th, the final plat is submitted to zoning and planning for review. July 14th, final plat is recorded at the Register of Deeds. And July 2023, subdivision appeal application SBDVAA-07-23-00004 was submitted to Charleston County Zoning and Planning. Summary of the appeal: Mr. Cunningham, with the South Carolina Environmental Law Program, on behalf of the 10 Mile Neighborhood Association, per his application, is appealing the approved subdivision plat based on ZLDR Section 8.1.2E, Certificate of Historic Appropriateness, and ZLDR 1111, Ordinance Compliance. Do you need me to wait a second, Marcia?
No, go ahead.
Go ahead. So this is the section of the ordinance that's being appealed. Certificate of Historic Appropriateness.
That's it. Thank you.
Staff response is, as of January 2023, subdivision plats are no longer taken to HPC due to conflict with ZLDR Section 1.9.1, which states if the provisions of this ordinance are inconsistent with those of the state or federal government, the more restrictive provisions shall control, to the extent permitted by law. On October 28, 2022, Certificate of Historic Appropriateness application for final plat was submitted and requested to be on the December 13, 2022 Historic Preservation Commission. At the December meeting, the applicant's representative, Mr. Leisman, requested to defer to the February 15, 2023 HPC meeting. The commission approved the deferral, and the application for final subdivision plat never went before the HPC after the December 2022 meeting. So I included this as an exhibit prior to, because it's a little wordy, but it's the South Carolina Code of Law, Section 629-340. And I won't read it word for word, but the important part of it is what are the functions and duties of the Planning Commission. The Planning Commission is a recommending body to council for comprehensive plans, ZLDR amendments, rezonings, plan developments, and you are the final decision-making body for plats and road name changes. And that is specifically written in Section 629-340 2B, regulations for the subdivision or development of land and appropriate revisions thereof, and to oversee the administration of the regulations that may be adopted as provided in this chapter. Also, in South Carolina Code of Law, Section 629-1150, this states the subdivision plat submission to the Planning Commission, recording an appeals process. And you can see it's pretty detailed in the administration of it. And then also, Mr. Cunningham mentioned in his presentation that the Planning Commission did not approve it. However, in Section A states, the land development regulations adopted by the governing authority must include a specific procedure to the submission and approval or disapproval by the Planning Commission or designated staff. You all have designated that to staff. So, subdivision plat reviews, preliminary, final, all is under the purview of the Planning Commission. So what is the Historic Preservation Commission responsible for per law? You go to Section 629-870 of South Carolina Code of Law, and it specifically states, by means of restriction and conditionings governing the right to erect, demolish, remove, in whole or in part, or alter the exterior appearance of all buildings or structures within the areas may provide for appointment of the Board of Architectural Review or similar body. Nowhere in this section does it mention plats. Also, for reference, the South Carolina Department of Archives and History, Historic Preservation under local governments also references Code of Law Section 629-870 as amended and reiterates that the Historic Preservation Commission is responsible for restricting or placing conditions on exterior alterations, additions, demolitions, or relocations of structures in the historic areas. This board, on the August 14th Planning Commission agenda, reviewed the zoning ordinance in regards to subdivision plats going to HPC, and the commission voted 6-2 recommending approval to remove it, understanding that it's in conflict with state law. The public hearing for this is scheduled for September 12th. On June 12th, the Planning Commission also reviewed 2 similar appeals for a separate subdivision for the 3906 Seafood Road, and the Commission voted unanimously 8-0 to deny the appeal and affirm the administrative decision. The appellant references ZLDR Section 1111, which states ordinance compliance. As noted in the presentation, staff administered approval and recording of SBDV 0922-02205 within full compliance of the ordinance. Based on the information presented, the administrative official did not err. Staff recommends the following findings of fact and conclusions of law. Findings of fact: the preliminary plat was approved on September 21st, 2020, before the 10 Mile neighborhood was designated a historic district. The revised preliminary plat was approved on August 5th, 2021, before the 10 Mile neighborhood was designated a historic district. And the final plat application, HIST 1122-000064, was deferred in the December 2022 HPC meeting and never voted on. The conclusions of law: South Carolina Code 629-340 and 629-1150 grants plat review authority to Planning Commission or designated staff. Section 629-870 outlines the powers and duties of boards of architectural review and similar bodies, but does not grant such bodies plat review authority. And ZLDR 1.9.1, conflict with state law or federal law. Final plats going before the HPC would conflict with South Carolina Code of Law 629-340, 629-1150, and 629-870.
We appreciate the staff's presentation. Is there a motion and a second?
Could move that the staff recommendation be approved. Is that appropriate?
Approve the findings of fact and conclusions of law. Okay, so there's a motion for approval of the findings of fact and conclusion of law as recommended by the staff.
I'll second that.
And there's a second for Mr. Paulotis. Any discussion?
Yes. I'm kind of confused, and maybe y'all can help me out here with this. The one that we had before, the finding on the final order for that one, it was based upon the finding on the final order for that one, it was based upon the Joint Permit Resolution Act, that it was a timing issue or a suspension of application. There was an allegation that the preliminary plat had expired before the final plat was approved. We never really got into the merits of that. That was because of this Joint Permit Resolution Act by the General Assembly. If you go back and read the final order, that's what it says. There was no reference to any of the other stuff that's been.
May I? This appeal was not appealed based on the preliminary plat. It was only appealed based on the certificate of historic appropriateness.
Correct, but the other involved that same thing. And in fact, it was the preliminary plat, between the preliminary plat and the final plat, more than 2 years had transpired before this historic appropriateness thing had been addressed, and therefore the preliminary plat expired because it had been over 2 years, and it didn't get the required appropriateness, certificate of historic appropriateness. But here's my concern with it, I guess. These are newly adopted ordinances by county council. They've gone through the proper procedure to be adopted. They should be in full force and effect. According to my understanding of the law and how this works, the only entities that can modify any of that is the elected body itself that adopted it, or a court of competent jurisdiction. There's something out there called the equal dignity doctrine, and it basically says that, at least with respect to an ordinance adopted by a local governing authority, that the only way that it can be changed is through an adoption of that ordinance, of a change, or you can delete it, whatever you want to do with it. Of course, it can always be appealed to a court that has authority over it, and their decision would hold. Unless it's appealed, then it goes on up to perhaps even the state Supreme Court or beyond. But I don't think staff has the proper authority to say an ordinance cannot be enforced, or the standards of an duly adopted ordinance are inapplicable and can't be applied. The proper thing there would be to change it, and then once it's changed, then those standards are in place. I guess what I'm asking here, too, is was a certificate of appropriateness approved or denied, or was it entertained for this subdivision?
It did not. It was deferred, and it never went before the board.
But there was an application made.
There was an application.
And it was accepted. They paid the money, the application went forward, it appeared on an agenda.
Correct.
Is that correct? Okay. And then it was deferred. But the way I read the ordinances that are still in place, what should have happened before the final plat was approved was that this certificate of historical appropriateness should have been approved. Is that not correct?
That's not correct, because it would have been in conflict with state law.
Well, forget that part for the time being. The ordinances that are in place now with the county, it says that's the proper procedure. Is that not correct?
That is the ordinance.
So the answer is affirmative. That is correct.
It would be correct if it wasn't in conflict with state law.
Let's not even talk about that. What's on the books right now, it says that you're supposed to get this certificate of historical appropriateness before the final plat is approved, correct?
That is what the ordinance states.
And the county was in possession of an application to accomplish that, correct?
Yes.
But it never happened, and yet the final plat was approved regardless. Is that correct? Are these all correct factual statements?
Yes.
Okay. So I don't see where there's any conflict to this at all. I mean, the county adopted ordinances that said this is what you have to do. Okay? And if it's in conflict with state law, the entity that needs to declare that is a court of competent jurisdiction, not county staff. And let me just, I guess, ask this question. I think I'm understanding this correctly, but it'd be good to get it in the way of a legal answer. And actually, from here and going forward, I think these are very difficult and weighty matters. I would prefer to get legal opinions in writing through attorney-client privileged memorandums or executive session briefings, and not just run into stuff at a meeting without having the information ahead of time. But I'm thinking what I'm hearing now is that based on this provision 1.91 of the county code, where it basically says if the county ordinances are in conflict with a state or a federal provision, that the more strict shall apply. Is that not a correct interpretation of what that says?
I have it on the screen for you.
I don't see it. Oh, provisions. Okay, the more restrictive provision shall control. That's what it says. It appears to me the more restrictive provision is that a certificate of a historic appropriateness is required, where otherwise it would not be.
Okay, Mr. Prosser, would you like to hear, maybe we could hear from legal on this?
Sure.
See what their
Love it.
position is?
Members of the commission, the county attorney's office position is that pursuant to Title VI, Chapter 29, 340, the planning commission is charged with administering subdivision requests and has delegated that authority to planning staff pursuant to 629, 1150. The planning commission has not designated authority to any other body such as the HBC. Furthermore, any discrepancy in the ZLDR about the review of the subdivision request is in conflict with state law, and state law must control. Here in ZLDR 1.91, it says the provisions of this ordinance are inconsistent with those of the state or federal government. The more restrictive shall control to the extent permitted by law, and state law does not prevent the delegation to any other body but the planning commission or designated staff.
Well, thank you for that. With respect, I'd like to address that, what you said. I think, and please correct me if I'm wrong too, those are provisions of the state code. Is this working right?
Yes.
Can you hear me good? And it says that the planning commission can approve plats, preliminary plats, final plats, or it can be delegated to staff. My understanding is that the county, through its code, through its zoning and land development code, the subdivision regulations portion of it, designates that the staff is the appropriate authority to approve a final plat. And I believe the planning commission is responsible for approving preliminary plats in the county code. From what I further understand, it appears that the planning commission has chosen upon its own authority to delegate that position to staff, which, in accordance with the state law, that should be done through an ordinance amendment by county council and not through planning commission saying staff's going to do it. Just to start off.
I think that's what we were attempting to do last month, was to correct that and go up to county council to get that part of it corrected.
Well, I have a different recollection, but at any rate, the laws that are on the books are the ones that you go by. If you're intending to amend it, that's fine, but it doesn't become effective until it is amended. The laws that are on the books are the ones that are in full enforce or effect unless they're amended or unless a court says otherwise.
I think that says we follow this unless it's in conflict with with state or federal law. So this was, our previous ordinance was in conflict with state law. So we would not follow that.
Well,
if it was in conflict.
And perhaps it was, perhaps it wasn't. I don't know. As I read it, and the historic ordinance is actually under Chapter 25. It's not even in.
Okay, well, I think we get your position. So is it okay with you if we see if anybody else wants to participate, or if not, we can call the question?
Well, I would like to get some facts in the record, if that's okay. You can if I'd be perfectly willing to yield to anyone else if they want to make some comments. But I would like to make some further factual findings.
Are you wanting to amend the motion that's on that's up for presentation now?
It could come to that. I'm just trying to figure this stuff out. And if you'll indulge me just for a couple more minutes, and I'll use a term that's used in the military, FUBAR. It appears that this is kind of FUBAR'd. And the first word is a cuss word. I won't say that, but it's the rest of it is okay. But it's basically fouled up beyond recognition. And it appears that the elected officials want to do something to protect these historic settlement communities. And in my personal and professional opinion, having been a planner for 33 years, I would posit that one of the most significant, at least the most significant visual representation of the historic fabric of these settlement communities is in the physical built environment. And all you have to do is look at a map. I mean, we have a map here that shows it in a very limited context, but I looked at it on the GIS at my home computer, and you spread it out amongst the whole neighborhood. You can clearly see that the underlying R4 zoning that's there allows an inappropriate development pattern in these communities that if it continues will ruin the way they look and will severely compromise their historical significance. So, as Yogi Berra says, you got to know where you're going, or you might never get there. What's trying to be accomplished? I'm trying to understand it too. The Chapter 25 is not under the zoning code. The provisions for a Board of Architectural Review under the Comprehensive Planning Act, Title VI.
And Commissioner President, if I can interrupt, do you have a question for staff that could help you in your deliberation?
I think so.
Could you put it forth succinctly? Because you seem to be all over the map.
Well, it's because it is all over the map. And I've had this conversation with staff. Typically, if historical districts are usually in zoning codes as overlay districts. This is a completely separate and independent thing. And I'm not so sure that in accordance with the state law requirements, it even is an architectural review board is contemplated by the Comprehensive Planning Act. And you also heard testimony already that there were other things besides just the subdivision of this property that were.
And Commissioner Chair Floyd, if I can interrupt again, I would like to remind them, the body, that the historic preservation and aspect of this is not what is really been before you. If there are questions about that may be helpful, we can answer them. But all the comments about what the HPC did or did not do would be anecdotal to this. We are simply asking whether or not the planning staff erred in issuing the final plat.
All right. Well, I'll go back to that then. In accordance with what rules are the ordinances currently written and adopted, it appears that the staff did err. And we'll just wait and see how the motion goes.
Okay. The motion is to accept the findings in fact and conclusions of law as recommended by the staff, which we already have up here.
Thank you for your indulgence. I appreciate it. I do.
You want to read those out so he can be clear?
The findings of facts and conclusions? Yes, ma'am.
Okay.
Findings of fact, the preliminary plat, SBDV 05-19-01171, was approved on September 21st, 2020, before the 10 Mile neighborhood was designated a historic district. The revised preliminary plat was approved August 5th, 2021, before the 10 Mile neighborhood was designated a historic district. The final plat application went to Historic Preservation Commission, application number HIST 1122000064 was deferred in the December 2022 HPC meeting and never voted on. Conclusions of law. South Carolina Code of Law, Section 629-340 and 629-1150 grants plat review authority to Planning Commission or designated staff. Code of Law 629-870 outlines the powers and duties of boards of architectural review and similar bodies, historic preservation commissions, but does not grant such bodies plat review authority. And ZLDR Section 191, conflict with state or federal law. Final plats going before the HPC would conflict with South Carolina Code of Law Section 629-340, 629-1150, and 629-870.
And the conclusion is the preliminary plat approval did not lapse because the permit extension of the joint resolution extended the approvals? Or is that from last time?
That's a
That's a separate one, okay. Never mind, I'm at the wrong place in my little thing. Okay. All right. Are we ready for the vote? Does anybody else have any discussion? Okay. Would you call the roll, please?
Commissioner Logan Davis. Aye. Commissioner Marlena Davis.
Nay.
Chair Floyd.
Aye.
Commissioner Jones.
Aye.
Commissioner Kent.
Aye.
Commissioner McConnell.
Aye.
Commissioner Morris.
Aye.
Vice Chair Pilatos.
Aye.
Commissioner Praza.
Nay.
The ayes have it.
Next item, as we go through this again.
Yes.
Oh, boy. The Planning Commission is a decision-making body regarding subdivision-related appeals and of administrative decisions. Any person with a substantial interest in this decision or the Planning Commission or any officer, board, or bureau of the county may appeal the final decision of the Planning Commission to the Circuit Court of the Charleston County. Appellant shall file with the court clerk a written petition plainly and fully setting forth how such decision is contrary to law. Such appeal shall be filed within 30 calendar days after the decision of the Planning Commission is mailed. Okay. All right, the next agenda item is an appeal for a subdivision-related administrative decision, case number SBDVAA-07-23-00005, regarding the approval of a final subdivision plat for 978 Gadsdenville Road, parcel identification number 614-0000178. Pursuant to Article 3.4, Appeals of Subdivision-Related Administrative Decisions of the Charleston County Zoning and Land Development Regulations Ordinance, an appeal shall be sustained only if the Planning Commission finds that the administrative official erred. The decision of the Planning Commission shall be accompanied by specific written findings of fact and conclusions of law, clearly stating the reason for the decision. At least two-thirds of the members present and voting shall be required to reverse any order, requirement, or decision or determination of any administrative officer or agency. Again, the order of hearing on this case will be as follows. First, the staff will give an overview of the appeal application. Then the applicant will be given 5 minutes to speak. Following that, I will call each person who signed up to speak, with each speaker limited to 2 minutes. The case will then be closed to public comment, and staff will make a presentation regarding the application. I will then request a motion and a second. Discussion can occur after the motion is made and seconded, and then we will vote. Ms. Avery, would you please present the case?
Yes, ma'am. Subdivision Appeal Application SBDVAA-07-22-00005. It appeals the subdivision of 978 Gadsdenville Road, which subdivided the property into 10 lots. The property owner is Gadsdenville LLC. Property size is 4.962 acres. The zoning district is R4, and the final plat was recorded at the Register of Deeds office June 30th, 2023, in plat book L23, page 0256. This is the future land use map of the property, the current zoning map of the property, aerial view of the property, recorded plat of the property, the South Carolina Environmental Law Project, on behalf of the 10 Mile Neighborhood Association, is appealing the administrative decision to record the final plat based on ZLDR Section 8.1.2E, Certificate of Historic Appropriateness, ZLDR Section 8.4.6, Lapse of Preliminary Plat Approval, and ZLDR Section 11.1.1.
Good afternoon. This appeal relates to the Gadsdenville Road development, the Enclave. Perhaps I should start with this. It wasn't just that the Certificate of Historic Appropriateness for all of these was deferred. It was denied by the HBC, first of all. Second of all, in order for there to be a conflict, it must be expressed. It must be inconsistent between the two. And from what we've heard so far, the idea is that this commission is the only one that can vote on final plats or address plats. That's not what the HBC is doing. The HBC is saying, is this development consistent with the historic character of the area? The Historic Preservation Commission is not approving plats in any form. The Charleston County Council and more particularly the subdivision regs have said, you know what? We want to incorporate this body's decision in our decision-making process, which is completely appropriate, especially considering that body is the one who is focused on the historic appropriateness of development. What better way to get an authority's determination prior to development than delegating some authority to that? There's nothing in 629-340 that says the county or this body can't delegate some of its finding related to plats, is not approval of plats, to another body, which is what it did, what the county council did when they approved both the historic preservation ordinance and the ZLDR that incorporated that provision into it related to final plat approval. The Gadsdenville Road, just like Watson View, is in 10 Mile Historic District. Just like Watson View, it did not, it's nice to be working in the construction zone. Watson View, Gadsdenville Road, and Seafood Road, none of them had certificates of historic appropriateness prior to final plat approval. And Commissioner Prowse is correct in that the prior Seafood Road appeal, the decision was made solely on the applicability of the so-called permit extension resolution. It didn't even address the lack of historic preservation, or excuse me, the lack of historic appropriateness certificate, which is one of the issues we raised in our appeal. So here, again, you have an express ordinance that is on the books, that is in effect, that county council promulgated, and staff is saying, well, we don't like it because we think it conflicts with some other state law. Well, in order for there to be a conflict, it has to be inconsistent and irreconcilable with each other. That's what the South Carolina Court of Appeals and Supreme Court have said. There's nothing irreconcilable about the Historic Preservation Commission weighing in on a historic appropriateness that this body and staff then use in their decision-making authority and in making decisions on final plat approvals, which is what is supposed to happen and which has not happened in any of these developments. We just ask that this body apply the law as it is now without some conjecture about whether or not it's in conflict with state law. And if it's in conflict with state law, let's see the state law it's particularly in conflict with. There's nothing that's been shown on that screen that says the Historic Preservation Commission is somehow usurping your authority on final plat approvals. All that says is, what do you know? Planning commissions can address final plats. and their staff can address preliminary plats if so delegated. That's fine. There's nothing that the Historic Preservation Commission has done that usurps that authority. We just ask that the law be applied as it is now, and then if there is some later change, then we can address that later. But right now, there is no historic appropriateness certificate for this property or any of the others, and yet they're getting final plat approvals. That's wrong. It's an error. We'd ask that you change and reverse the staff decision. Thank you.
Now we go to the public. All right. Ellis Gleesman?
Excuse me, Madam Chair?
Yes.
May I ask a question of the former applicant before we move on to the next one, or should I wait till after Mr. Leisman?
Go ahead and ask.
All right. Mr. Cunningham, I noticed in your application that you had made reference that you didn't think that this joint permit resolution act applied to these, or at least to this particular item that's before us. I didn't really quite understand that. Could you explain that for us, please?
May please, Commission. Yes. That was before we had information about a revision of a preliminary plat, which therefore we are not pursuing that. Now, unlike the Seafood Road, where there was no revision, and we have a lot of arguments about why the joint permit extension bill does not apply to these types of decisions, mainly because of the history of that resolution and also the failure of any county, including Charleston County, to publish any intent to have that resolution apply in the state register subsequent to the promulgation of that resolution. But given that there are some revisions within the 2 years, we are not pursuing that currently for this. All right.
Thank you very much for that. Thank you.
Thank you.
Now.
Would you like your presentation?
Oh, yes. Thank you, Ms. Avery. Madam Chair, Ellis Leisman on behalf of the property owner. And Mr. Krause, I'd like to also start with a question you just addressed, because I want everyone to be comfortable with the decision that you made before, although I've got a limited amount of time. The Joint Permit Resolution Act absolutely applies to every subdivision of the state. This state is divided into 46 counties. They're all subdivisions of the state, and that law says it applies to all development-related permits. So it absolutely applies. However, it didn't come up in these cases, these two appeals, because in the prior appeal, that was the only instance where there was more than a 2-year gap between the preliminary plat approval and the final plat approval. And again, why did a lot of those gaps occur? Because of COVID, which was what motivated the General Assembly to pass that resolution in the first place. So ladies and gentlemen, clearly this is a controversial topic, but let me just let you know, this property was purchased for $625,000 from 2 members of the 10-mile community. It was purchased in accordance with a real estate contract that was 18 pages long. There's been $3.3 million worth of expense that's been incurred. And when we're looking at these issues, and we're looking at issues of equal dignity like Mr. Prowse raised, a ordinance that's invalid has no dignity. And if an ordinance gives power to regulate density to the HPC, when that power has already been given to the Planning Commission, there's the conflict that cannot be reconciled. So that you could have a preliminary plat, like in this instance, that has 10 homes. You could build out the lots, you could build the roads, you could install everything there, and you could go in front of the HPC and they could say, you know what? It's just too dense. And that's what they're doing. And that's what's messed up beyond recognition and the county is fixing. But at the end of the day, the preliminary plat that the staff approved was not an error. It merely outlines the lots and the roads. And the final plat is the conclusion of that plat process, just to say, you built this in accordance with the preliminary plat that we also approved. Those do create vested rights. And that's another issue that would be an irreconcilable conflict if this board were to allow for this appeal to be approved. Would ask you just to revisit the same decision that you'd made in the prior 2 appeals. Thank you, Madam Chair, for giving me a few extra seconds. That decision was legally correct. It was factually correct. These developments were well underway before, in June of 2022, the historic district was first recognized. It was purchased for that purpose, and it was being used for that purpose. And again, I don't want anybody to feel like the historic preservation district is being ruined or canceled. Mr. Evans and others are working diligently to try to say, are we going to lay restrictive covenants on these properties? Are we going to change the density that's allowed? And has actually not met with a lot of support, to my understanding, for those types of things. The historic preservation ordinance does exist, the district exists, but these preliminary plats and that construction occurred prior. So there's about 470 parcels in the 10-mile district. These three are unique. Copahy, that was before you before, and these two are unique because they are ones where there was already an approved subdivision plat and investment and vested rights before that district was imposed on these three properties and on various people without their consent. They didn't vote for it. They didn't ask to be included. So your decisions have been correct in June. Your decision was correct a few minutes ago, and would ask for you just to maintain that and to deny this appeal. Thank you.
The case is now closed to public comment. Oh, sorry. With it today, I don't know. Okay, Filippo Ravalico.
Filippo Ravalico, 510 Live Oak Drive, Mount Pleasant. Good afternoon again. So you just approved a finding of fact which is false, because the HPC did rule on the application for certificate of historic appropriateness on all three developments, and they denied it. It's in July. Mr. Leisman can tell you that he's suing the HPC and the county for that vote. So what are we doing here? You know? By the way, it was denied not only because of density, like what Ms. Ellis just said, it's based on criteria A, criteria C, and criteria D. Density is criteria D. So are we playing, are we living in an alternate reality? You know, I liked, we understand there's a lot of litigation pressure on the county. It's complicated matters, and Commissioner Prowser spoke eloquently about it a minute ago. Mistakes might have happened, and I guess not only on one part. Maybe there's some mistake on the part of the developer, maybe there's some mistake on part of staff, maybe even the attorneys, the community. The point is that if we don't learn from the mistake, we're going to keep repeating them. And holding accountable staff for their mistake is one of your functions. You let them go, you let them make you vote based on patently false information. Dignity. Commissioner Davis, do you have any dignity? Commissioner Jones, do you have any dignity? Commissioner Kent, do you have any dignity? Madam Chair, Ms. Floyd, do you have any dignity? Vice Chair, Commissioner Palatus, do you have any dignity? I don't see your name, Commissioner. Do you have any dignity? Mr. McConnell, do you have any dignity? Thank you.
Mr. Evans, would you like to?
Yeah, I want to clarify something that's come up a couple times, and these are the facts about the HPC and what you're hearing today and what's been brought up that was supposedly approved earlier. What's before you is the plat issue on the two subdivisions that are before you. When the appellant gets up and refutes that and says that there was a decision in July, what was disapproved in July by the Historic Preservation Commission was the individual houses, the structures that went before the HPC on the lot that had already been approved. So that is the difference. I just want to make sure that the Planning Commission understands that differentiation.
Okay,
that we are looking at the lots.
They disapproved a house that
They've disapproved the houses on all of the...
on an approved lot.
On an approved lot, correct. So that is what was disapproved in July, not the plats. The plats on these cases were never decided by the Historic Preservation Commission. All right? And Tamara will go over that again in her presentation.
Okay, so background on this property. In August of 2019, preliminary plat was submitted for review. May of 2020, preliminary plat was approved by staff. October 21st, or October 2021, a revised preliminary plat is approved by staff. June 2022, 10 Mile Community is designated as a historic district. October 2022, final plat is submitted to zoning and planning for review. May 19th, South Carolina Governor McMaster signed South Carolina Bill H.3209, Permanent Extension Joint Resolution of 2023 into law. June 30th, 2023, final plat was recorded at the Register of Deeds office. And July 26, 2023, subdivision appeal application SBDVAA-07-22-00005 was submitted to Charleston County Zoning and Planning. The summary of this appeal by Mr. Cunningham on behalf of the 10 Mile Neighborhood Association per his application is appealing based on ZLDR Section 8.12E, Certificate of Historic Appropriateness, ZLDR Section 8.4.6, Lapse of Preliminary Plat Approval, and ZLDR Section 11.11, Ordinance Compliance Required. Again, this is the section of the ordinance, ZLDR Section 8.1.2E, Certificate of Historic Appropriateness. Staff response: as of January 2023, subdivision plats are no longer taken to HPC due to conflict with ZLDR Section 1.9.1. If provisions of this ordinance are inconsistent with those of the state or federal government, the more restrictive shall control to the extent permitted by law. October 28th, 2022, Certificate of Historic Appropriateness application for final plat was submitted, requested to be on the December 13th, 2022 HPC. At the December 13th, 2022 HPC, the applicant's representative, Mr. Leisman, requested to defer to the February 2023 HPC meeting. The commission approved the deferral. The application for final subdivision never went before the HPC after the December 13th, 2022 meeting. The appellant's application of appeal for subdivision states the plat went before the HPC in July 19th of 2023. That was denied. However, that's incorrect. It was for individual site plans, not the final plat, which Mr. Evans just explained. Again, this is the code of law we're talking about for Planning Commission, Section 629.340, which states the functions of plats go before the Planning Commission. This is Section 629.1150, which states the process of plats to the Planning Commission or designated staff. And I won't go through the whole presentation again because I just did it, but if y'all have any questions, just let me know. And then Section 629.870, Board of Architectural Review. This is where the Historic Preservation Commission falls within the South Carolina Code of Law, and states by means of restrictions and conditions governing the rights to erect, demolish, remove in whole or in part, or alter the exterior appearance of a building or structure within the areas, may provide the appointment of a Board of Architectural Review. So in nowhere in the South Carolina Code of Law does it state that HPC reviews plats. However, Mr. Cunningham mentioned that the Planning Commission could delegate authority for review to the HPC, which it has not. So Planning Commission is the only governing authority that has the rights to approve plats. The South Carolina Department of Archives and Historic Preservation Legal Government states that the Historic Preservation Commission by Section 629.870 has the authority to restrict placing conditions on exterior alterations, additions, demolitions, or relocations of structures in those areas. It does not mention subdivision plats. This commission, on the August 14th, 2023 Planning Commission agenda, reviewed the ordinance and voted 6-2 recommending approval, taking the final plat approval for historic, or the need for a historic certificate of appropriateness for final plats out of the ZLDR. Public hearing is tomorrow. And again, this commission also saw two subdivision appeals in June 12th of 2023 for similar appeals, and the commission voted unanimously 8-0 to deny the appeal and affirm the administrative decision. In regard to the appellant listing ZLDR Section 846, lapse of preliminary plat approval, that's the section of the ordinance he's appealing. The South Carolina Bill H.3209 Permit Extension Joint Resolution of 2023 extended the preliminary plat approval period. It's a copy of the final order, which was an exhibit in your packets. Section 2.2 states, development means the division of a parcel of land into two or more parcels, which that is a subdivision plat. Section 2.3a states, development approval means the approval issued by the state, an agency, or subdivision of the state. In South Carolina Code of Law, Title I, Section Administration of Government, Section 16105 states, and it defines political subdivision includes a county, city, municipality, town, village, township, district, authority, special purpose district, school district, or local government entity, or any public corporation or entity, whether organized or existing under charter or general law. Therefore, in South Carolina Code of Laws, Title IV is all about the structures of counties. Section 3 gave a timeline for approval. For development approval that is current and valid at any point during the period beginning January 1st, 2020 and ending December 31st, 2023. The running of the period of development approval and any associated vested right is suspended during the period beginning January 1st, 2020 and ending December 31st, 2023. Again, the timeline for this property: May of 2020, the preliminary plat is approved by staff. October 2021, revised preliminary plat is approved by staff. October 2022, final plat was submitted to zoning and planning. In June of 2023, the final plat was recorded at the Register of Deeds office. And that's the section in the ordinance. If the appellant implied to appeal the preliminary plat, that's within 30 calendar days. The appellant also mentions ZLDR Section 1111, ordinance compliance. As noted in the presentation, staff administered approval and recording of SBDV-10-22-02227 within full compliance of the ordinance. Based on the information presented and the administrative official did not err, staff recommends the following findings of fact and conclusions of law. The preliminary plat SBDV 0819-01272 was approved on May 12th, 2020, before the 10 Mile Neighborhood Association was designated a historic district. The revised preliminary plat was approved on October 27th, 2021, before the 10 Mile Neighborhood was designated a historic district. The final plat application for Historic Preservation Commission was deferred in the December 22 HPC meeting and never voted on. Conclusion of law. South Carolina Code of Law, Section 629-340 and 629-1150 grants plat review authority to Planning Commission or designated staff. Code of Law 629A70 outlines the powers and duties of the Boards of Architectural Review and similar bodies, which is the Historic Preservation Commission, but does not grant such bodies plat review authority. ZLDR Section 191, conflict of state and federal regulations. Final plats going before the HPC would conflict with South Carolina Code of Law Section 629-340, 629-1150, and 629-870. The preliminary plat approval did not lapse because of the permit extension joint resolution of 2023 extended the development approvals current and valid at any point during the period between January 1st, 2020 through December 31st, 2023.
Okay.
Do you have any questions?
We need a motion and a second before we can.
I have a
Go to that.
question, if you don't mind. Is
First,
the,
excuse me, first we have to do the motion and a second.
I thought here it says questions by commission to official being appealed. This is the next slide that I have.
Okay. Before we can do questions and discussion, we should do the motion. So is there a motion?
I made a motion that we approve. Let me say, it is a very complex issue.
I don't doubt you there. Okay, is there a second? Yeah, okay. All right. Who's got the question? You got the question?
Yes, but I've spoken a lot. Mr. McConnell has a question. Let's let him go first.
Thank you. I just want to get real clear. We've spoken a little bit about vested rights and preliminary plats and these types of things. Can somebody please on staff or from our legal minds explain to me what rights are vested at the stage of preliminary plats and what they entail?
And Commission members, at the current stage, the applicant has the right to build whatever was built per his preliminary plats. As he said, they've already laid out infrastructure, including roads, I'm assuming drainage and whatnot. All that is already laid out according to the preliminary plat. Staff have looked at that plat and said, yes, what you have built is appropriate and based on what you said, and here's your final plat. And so therefore, they're allowed to do all that. They are also now allowed to construct homes on their plats and as well. So the confusion that may be arising, and HPC looked at the design of their house and voted to disapprove the design of the house, but they cannot vote to not allow them to build houses.
And I have along those lines. So you can go ahead and build out everything with a preliminary plat.
No, you can't build
And then-
anything with a preliminary plat.
But that's the
The
purpose of a
infrastructure.
preliminary plat, is basically you're providing to staff or the planning commission, we are going to meet the ordinance requirements for minimum lot size, minimum subdivision requirements. And then you, after staff approves it, that's when you start actually putting in infrastructure.
Okay. And then after the final plat approval, then you can start building houses.
Right, so the final plat just verifies that the neighborhood was built per the approved preliminary plat. All the infrastructure's in place and the permits are closed out. And then the final plat's recorded at the Register of Deeds. It gets mapped, gets individual TMS numbers. Then developers can pull individual building plans.
Permits, you mean. Thank you again. My first question is there a question of timing or expiration here on this appeal?
The appellant's application listed it. However, in his presentation, he said he wasn't.
Well, may I ask him again, is that a question that's before us for consideration, the timing aspect of an expiration of the preliminary plat?
Not anymore, Commissioner Cross, because of the revision.
Okay.
Within the 2 years.
All right.
Had it not been for that revision, yes, it would.
All right, thank you. So we don't need to address that issue. I guess in the way of a question too, and I know we're dealing with the zoning and land development regulations that are separate from the rest of the county code, of which the Chapter 25 addresses the Historic Commission. That particular matter is not directly in front of us. What is the requirement that a certificate of historic appropriateness must be obtained prior to final plat approval. Is that a correct understanding? Is the matter the main issue that we're dealing with?
So the appeal states.
The appeal application was appealing on the need for a certificate of historic appropriateness, lapse of preliminary plat approval, and compliance with the ordinance.
Okay, well, we've dispensed with the timing aspect of it. So I guess we are back to this one, and I believe I was heard that was going to have a public hearing before the elected body tomorrow. And at that time, there may very well be a pending ordinance invoked because of their first reading of an intent to change the ordinance. But up until that time, I would posit that the ordinance that's on the books is what should be in full force and effect. And I guess I'm maybe to understand absolutely, completely, and I'm a bit, I don't know, shocked, I guess is a proper word. The current position of the county administrative staff, legal and planning staff, is that because of this section 1.91, that some administrative official, at least in this case would be the planning director, has the authority to basically say an adopted ordinance in the zoning code or land development regulations is suspect, possibly suspect. It hasn't been defined by a court that way. Upon advice of legal counsel, that they then have the authority just to not to pretend like, essentially pretend like it doesn't exist. Is that a correct
No, sir.
interpretation of what
No,
I'm?
it's not correct. ZLDR Section 1.9.1, if the provisions of this ordinance are inconsistent with those of state or federal government, and for the more restrictive provision shall control to the extent permitted by law. Therefore, Historic Preservation Commission does not have the authority through South Carolina Code of Law to review plats. It's only listed under Planning Commission. Planning Commission has not delegated that authority to Historic Preservation Commission. So therefore, it's in conflict with state law, and to the extent that it was permitted by state law. It was never permitted by Planning Commission, therefore it's in conflict.
Well, let me ask this question then, in the chapter 25 has been stated already. There's absolutely no mention in there of this historic commission having any ability to review plats. All they do is make recommendations with respect to appropriateness of whatever is put before them. They're not approving a plat. That is done by staff, not even the Planning Commission, for final plats, as outlined in the ordinance. But who makes these determinations that it's inconsistent with state law, and then therefore an administrative official can essentially ignore the application of those provisions? What entity makes that determination?
Commission members, it is the position of the county attorney's office that pursuant to 629-340 and 629-1150, all plat review goes under Planning Commission and therefore has been delegated to staff. It is also the position of the county attorney's office that any conflicts with the ZLDR need to be resolved accordingly. The conflict is that right now HPC is trying to review subdivision plats, which is in conflict with both the ZLDR and state law. Therefore, planning staff has been told to not continue executing plat reviews through HPC and instead leave it where it's supposed to be, which is the Planning Commission, which several years ago was delegated to staff.
Thank you for that.
I look at it as following an illegal order in the military. So you have the authority not to follow an illegal order when you're in the military, even though most of the time you're supposed to do what your supervisor tells you to do. That's kind of how I put it in my head.
Thank you for that as well.
All right, where are we? We got a motion and a second. All right, is there any further discussion? All right. Can we call for the vote?
Okay. Commissioner Logan Davis,
Aye with dignity.
Commissioner Marlena Davis,
Nay.
Chair Floyd,
Aye.
Commissioner Jones,
Aye.
Commissioner Kent,
Aye.
Commissioner McConnell,
Aye.
Commissioner Morris,
Aye.
Vice Chair Pilatos,
Aye.
Commissioner Praza.
Nay.
The ayes have it.
The Planning Commission is a decision-making body regarding subdivision-related appeals of administrative decisions. Any person with a substantial interest in this decision of the Planning Commission or any officer, board, or bureau of the county may appeal the final decision of the Planning Commission to the Circuit Court of Charleston County. Appellants shall file with the clerk of court a written petition plainly and fully setting forth how such decision is contrary to law. Such appeal shall be filed within 30 calendar days after the decision of the Planning Commission is mailed. Okay. The next item on the agenda is the chair's remarks, and I have nothing further to say. Is there any further business?
No, we'll be getting with the Planning Commission later with a schedule for the subcommittees for the comp plan. That'll be coming up. Do we have the dates for those yet, Andrew?
Yeah, they start later this month. We've got all the first subcommittee meetings scheduled. If we need to have more than those subcommittee meetings, we'll schedule them, when we meet.
And those will be, all that information comes out this week.
Yeah, we'll send the packets out this week, but you all should have gotten calendar invites from Monica about a month or so ago for your first subcommittee meeting.
What time are those meetings?
It depends on which one you're on. I can get with you after and tell you which time yours is.
Okay, that'd be great. Thank you.
Sure.
Okay. If there's no further business, this meeting of the Charleston County Planning Commission stands adjourned. The Planning Commission will hold its next regularly scheduled meeting on Monday, October 9th in County Council chambers. I can't believe that blew through. Oh, that was a tough one. This is complicated.
Yeah.